to just move us on a little bit. And I know that, Chesson, you wanted to mention something about legal opinions. Maybe now's a good time.
Yeah, sure. So under the EU regulations, there's an annual requirement to review your legal opinions with your custodian. So it's really important to have that process reviewed on an annual basis. And that all forms part of the risk management procedures. So when you go live with UMR, you need to have risk management procedures enhanced. So the regulator is really keen to see what your policies are, your procedures, your agreements, and that's that kind of annual process of legal opinions and an audit as well.
Yes, I think the point is that not only do you need to put in place these documents, I mean, obviously operational infrastructure, but then also some of the legal infrastructure behind that, the legal opinions.
Just kind of related to that, actually, because I think it's also very relevant for people to think about. So obviously with your legal opinions, you've got your segregation opinion, but you also need your collateral and netting opinions to actually make sure the whole thing works. And in fact, if there are particular issues with the counterparty's jurisdiction or the jurisdiction where the collateral itself is being kind of segregated, in the EU and UK, there is actually a non-netting exemption where you do not have to exchange IM at all if that jurisdiction is not clean for netting, or indeed if the collateral arrangement wouldn't be enforceable. And there are some jurisdictions where actually, if we're talking about not being in scope at all, you don't have to do it because, and there are a couple of other exemptions in the rules that obviously people should make sure that, if they could fit into any exemption in the first place, that's an even better place to be.
Yeah, I'm sorry, because you mentioned exemption, for each regulation and each jurisdiction as they're written, the definitions of the exemptions differ from as you walk around the globe. So if you are trying to leverage an exemption, you need to have a discussion with your counterparty of what jurisdictions would apply to that regime, and then take a view on whether or not that exemption would apply. Now, we've seen lots of underlying beneficial owners like sovereign wealth funds or quasi-governmental entities who would like to take an exemption or leverage an exemption. But depending on how the regulations are written, whether it's under EMIR or whether it's under the HKMA regulations, the definition of sovereign or the definition of a governmental or a supranational entity, there's slight variations between them. So counterparties, we know we have asked counterparties to requested legal opinions to support their own definition of how they would classify themselves under a certain jurisdiction. And those are very much reliable to apply for an exemption. What we would and what we have seen is counterparties say, well, I believe I'm this, but you need your own counterparties to come along that journey with you, especially if we've seen similar counterparties not leverage that exemption at all.
And you talk about exemptions because Emma talked about exemptions. But actually, there's a whole kind of day one classification piece around, are you a financial counterparty or an NFC plus, right? So a lot of people are kind of re-asking themselves that question because perhaps in the first instance, they didn't give it much thought. Yeah. And so even there, particularly if you've got a third country entity, they have to ask themselves, what would they be? Were they an EU or a UK entity, which is actually sometimes not a straightforward question to answer.